decides what treatment is best for your child? Now, most people expect the government to protect children from dangerous treatments, even if their parents want it. But shouldn't the government need to prove harm beyond a reasonable doubt before criminalizing treatment? Sadly, that is not the question before the court in the case Chiles versus Salazar. Rather, it's a twisted attempt to use the First Amendment to strike down this Colorado law. So we'll take a closer look at the oral arguments next on the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach, Rise, and Generation Be Free. Glad you could join me today. Again, this is another one of those, they call it the First Amendment, but it's not. But it's really kind of a twisted case. The details are important, so if you want to find out my sources, go to constitutionstudy.com and look up this article. You'll find all the quotes, have links to where I got them, so you can double check my work. Now, I'll talk more about the website and ways you can support the Constitution Study at the end of the episode, but for now, let's talk about the case with this Colorado law against conversion therapy. Let's start with the arguments. First up, James Campbell for Ms. Chiles.
Thank you, Mr. Chief Justice, and may it please the court. Colorado forbids counselors like Kaylee Chiles from helping minors pursue state disfavored goals on issues of gender and sexuality. This law prophylactically bans voluntary conversations, censoring widely held views on debated moral, religious, and scientific questions. Aside from this law and recent ones like it, Colorado hasn't identified any similar viewpoint-based bans on counseling.
Mr. Campbell gets right to his point. Colorado has criminalized minors from seeking their goals on issues of gender and sexuality. He alleges because those goals are state disfavored or not politically correct.
These laws are historic outliers. In NIFLA, this court protected professional speech, highlighting the dangers of censoring private conversations between professionals and their clients. And this court rejected by name 2 lower court decisions upholding laws like Colorado's. But the 10th Circuit gutted NIFLA's speech protection.
NIFLA refers to the Supreme Court case, National Institute of Family and Life Advocates versus Becerra, Attorney General of California. The case involved the California Reproductive Freedom Accountability, Comprehensive Care and Transparency Act, or the FACT Act, which required that certain notices be posted in clinics that serve pregnant women, including the fact that California provided free or low-cost services, including abortion. The court held that the license notice likely violates the First Amendment.
Colorado insists that its law is subject only to rational basis review. Yet that would allow states to silence all kinds of speech in the counseling room, such as disfavored views on divorce or abortion. If heightened scrutiny doesn't apply, states can transform counselors into mouthpieces for the government.
Now, Mr. Campbell argues that since the Colorado law impacts a freedom protected by the First Amendment, strict scrutiny should be applied, while Colorado believes only rational basis review is required. This argument falls back on the court's interpretation of judicial review, setting a standard of how hard a government must work to infringe on your rights protected by the Constitution.
Here, Colorado can't satisfy any level of heightened scrutiny. It didn't seriously consider any less restrictive alternatives, and Colorado can't prove harm because it hasn't cited a study focusing on what's at issue here: voluntary speech between a licensed professional and a minor. Nor can Colorado deny that many people have experienced life-changing benefits from the kind of counseling that Ms. Chiles wants to provide.
Remember this question of Colorado proving harm, as it will become very important later.
First Amendment doesn't permit Colorado censorship. I welcome the court's question.
Mr. Campbell hangs his argument on the Colorado law violating the First Amendment's free speech clause, except the First Amendment says no such thing. It reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or of the right of the people to peaceably assemble and to petition the government for a redress of grievances. You see, the First Amendment prohibits Congress from making laws that abridge the freedom of speech, not the states. That's not to say this Colorado law doesn't violate the Constitution of the United States, just not the First Amendment. We'll get into the real violations later. Next comes Hashim Mooppan, amicus or friend of the court for the United States.
Mr. Chief Justice, and may it please the Court, Colorado's law is subject to strict scrutiny under the First Amendment for three straightforward reasons. First, the law restricts speech based on content and viewpoint. It prohibits Petitioner from counseling minor clients to help change certain feelings and behaviors. It is thus subject to strict scrutiny unless an exception applies. Second, the law falls outside the exception for regulations of conduct that only incidentally burden speech. There is no separate, non-speech conduct being regulated here. And professional medical treatment is not exempt from the ordinary First Amendment rule that strict scrutiny applies even to laws that generally regulate conduct, where those laws are triggered by the communicative content of speech. Third, the law falls outside any historically grounded exception. There is no longstanding tradition of states imposing this type of categorical prior restraint on the speech of therapists. I welcome this Court's question.
The exception, as I've already pointed out, is that this law cannot violate the First Amendment because Congress did not make the law. Lastly, we have Sharon Stevenson arguing for the state of Colorado.
Mr. Chief Justice, and may it please the Court. Throughout its history, this Court has recognized that state power is at its apex when it regulates to ensure safety in the healthcare professions. Colorado's law lies at the bullseye center of this protection because it prohibits licensed professionals from performing one specific treatment because that treatment does not work and carries great risk of harm.
Now, Ms. Stevenson has a point. The power to regulate healthcare professionals lies with the states and not the federal government. However, for her argument to be valid, she will have to show that this treatment includes the risk of actual harm.
No court has ever held that a law like this implicates the First Amendment, and for good reason.
I don't know whether courts have upheld this or not, but I've already shown that this law cannot implicate the First Amendment, only not for the reasons Ms. Stevenson will use in her argument.
First, the law applies only to treatments. That is, only when a licensed professional is delivering clinical care to an individual patient. In that setting, providers have a duty to act in their patient's best interest and according to their professional standards. The First Amendment affords no exception.
Who decides what is in a patient's best interest? Does the state, with all the political baggage that comes along with it, really believe their view of what's best supersedes everyone else's? Apparently so.
Second, because this law governs only treatments, it does not interfere with any First Amendment interest. It does not stop a professional from expressing any viewpoint about that treatment to their patient or to anyone else. And because Colorado's law regulates treatments only, and because it enforces the professional standard of care, the law falls squarely into the reasonable regulation of professional conduct that does not trigger First Amendment scrutiny.
We'll encounter this phrase, standard of care, a lot in this case. What is standard of care? Well, from NIH's National Library of Medicine, we read, the standard of care is a legal term, not a medical one. Basically, it refers to the degree of care a prudent and reasonable person would exercise under the circumstances. State legislatures, administrative agencies, and courts define the legal degree of care required. So the exact legal standard varies by state. So the phrase standard of care is not a medical term, but a legal one, a term established by state government, which means Ms. Stevenson's argument boils down to the Colorado law is meant to enforce the standard of care by establishing it as the standard of care. Circular logic, anyone?
Petitioner's argument, on the other hand, cannot be reconciled with history, precedent, or common sense. A state cannot lose its power to regulate the very professionals that it licenses just because they are using words.
Ms. Stevenson is right. However, the Constitution of the United States does put limitations on states' power to regulate professionals, just not in the First Amendment.
A healthcare provider cannot be free to violate the standard of care just because they are using words. And a state cannot be required to let its vulnerable young people waste their time and money on an ineffective, harmful treatment just because that treatment is delivered through words.
Ms. Stevenson seems to imply that the standard of care is a medical standard, but as I've shown, it's not. This is the state prohibiting treatment that it believes ineffective and harmful without showing real proof.
Petitioner asked you to enjoin a bipartisan law passed by 25 different states, but she did not put one single piece of evidence into the record. Not a single expert, not a single study, not a single mental health professional willing to endorse conversion therapy. And there is a mountain of evidence to the contrary.
So Colorado wants the Supreme Court to deny the preliminary injunction against the law. Why am I reminded of something most mothers have said? If all of your friends jumped off a bridge, would you follow them? Because Ms. Stevenson seems to imply that Colorado should be able to enforce this law because other states have similar laws. Does that mean those laws are legal?
On this record, we request that you affirm the denial of preliminary injunction. I welcome your question.
I think now would be a good time to look at the details of these arguments under the scrutiny of the questioning of the justices. In his questioning, Justice Thomas brought out an interesting point.
In its introduction of its brief, Colorado says that the only thing that the law prohibits therapists from doing is performing a treatment that seeks the predetermined outcome of changing a minor's sexual orientation or gender identity because the treatment is unsafe and ineffective.
Colorado claims their law prohibits treatments that seek a predetermined outcome, but only if that outcome is to change a minor's sexual orientation or gender identity. They claim that talk therapy is only dangerous if it tries to effect such a change, regardless of whether that is the desire of the individual or not. While there was some wiggling by Ms. Stevenson, I think Justice Alito got to the point.
So in the first situation, an adolescent male comes to a licensed therapist and says he's attracted to other males, but he feels uneasy and guilty about those feelings. He wants to end or lessen them, and he asks for the therapist's help in doing so. The other situation is a similar adolescent male comes to a licensed therapist, says he's attracted to other males, feels uneasy and guilty about those feelings, and he wants the therapist's help so he will feel comfortable as a gay young man. It seems to me your statute dictates opposite results in those two situations based on the viewpoint expressed. One viewpoint is the viewpoint that a minor should be able to obtain talk therapy to overcome same-sex attraction if that's what he or she wants, and the other is the viewpoint that the minor should not be able to obtain talk therapy to overcome same-sex attraction, even if that is what he or she wants. Looks like blatant viewpoint discrimination.
I agree. That does sound like blatant viewpoint discrimination. The same person going to the same therapist is allowed different treatment based on the outcome the person desires. This is where Ms. Stevens tries to wiggle around the facts a bit.
As I heard your examples, I think they would both be permissible because it didn't sound like in either case the goal was to actually change sexual orientation. And again, that's the touchstone because that's where the harms come from.
Well, wait. Isn't wanting to end or minimize same-sex attraction an attempt to change sexual orientation? What if someone is heterosexual but has unwanted same-sex feelings? Wouldn't encouraging them to feel comfortable as a gay young man be changing their sexual orientation? Mr. Campbell reinforced this point in his rebuttal.
This law's viewpoint discrimination is even worse than we've heard so far this morning because the state of Colorado would allow a 12-year-old without their parents' consent to enter into counseling that would go the opposite way on these issues of gender identity and sexual orientation. But if that same 12-year-old with their parents' consent want to seek counseling in the opposite direction, the kind that my client would provide, they are not able to do that. That kind of viewpoint discrimination must survive strict scrutiny.
Then Alito opens an interesting door regarding standard of care.
Your argument depends very heavily on the standard of care, which I take it is defined by a medical consensus. Is that correct?
That's correct.
Except, as I've already shown, standard of care is not a medical term, but a legal one. It's determined by legislatures and agencies, not doctors. And history has shown that the term medical consensus is often used when no consensus exists.
Have there been occasions, the medical consensus is usually very reasonable and it's very important, but have there been times when the medical consensus has been politicized, has been taken over by ideology?
We have no facts about that in this case, but I wouldn't disagree that that's possible.
Yeah, that's possible. Recent history has shown that this alleged medical consensus has not only been politicized, but absolutely wrong. The medical consensus was that the COVID-19 vaccines were safe and effective, but actual medical research has brought into question their very safety. Seeing how many prominent people who were fully vaccinated yet got COVID proves it was not effective. So we not only have viewpoint discrimination, but the false statement that it's based on the standard of care being medical consensus, when in reality, it's a legal term used by political bodies. One of the questions that came up during oral arguments is Ms. Chiles standing to bring the suit. Now, Justice Sotomayor brought this up during her questioning of Mr. Campbell.
If they disavow enforcement of that kind of talk therapy, do you have standing in this case?
One of the claims from Ms. Stevenson was that if all the therapist did was talk to her subject, then the state would not enforce this law. She is an attorney, isn't she? Even if the state promises not to enforce certain parts of the law, does that not make the law valid? After all, if the law says one thing, can we really trust any state actor that someday someone won't enforce it? Because Mr. Campbell showed the lie in the disavow statement.
We still have standing in this case. Over the last few weeks, there have been anonymous complaints filed against my client, and those complaints are now being investigated by the state of Colorado for allegations that she's violating the very law that we're challenging. So we had a credible threat of enforcement before because there's no disavowal. Anyone can file a complaint at any time, which this court recognized bolsters a credible threat of enforcement in SBA list. But now that the state is actively investigating our client for supposedly violating this law.
So apparently, Colorado has not disavowed the law, and even if they did, would that really redress the grievance Ms. Chiles has? One of the legal questions many court watchers were talking about was the relationship between this case and their Skrmetti case the court decided last session. Justice Jackson brought that up while questioning the United States Attorney, Mr. Mooppan.
Can I ask you just one final question, just sort of from a very broad perspective? I'm wondering why this regulation at issue here isn't really just the functional equivalent of Skrmetti. I mean, I realize that there were two different constitutional provisions at issue, but the regulations work in basically the same way, and the question of scrutiny applies in both contexts. So it just seems odd to me that we might have a different result here.
Justice Jackson brings up a good point. How is this case different than Skrmetti? Because in the Skrmetti case, the court found that the state had the power to regulate medical treatment.
Well, Skrmetti was a law that regulated on the basis of age and medical treatment.
Not a very good start from Mr. Mooppan's defense here, because this law also regulates based on age and medical treatment, even if it's psychological treatment.
No, but here's what I mean, right? In Skrmetti, we had a state that wanted to prohibit certain medical treatment, gender-affirming care, being given to minors in the form of medication. And we said that was okay, and I understand there are particulars with respect to how the arguments, the constitutional arguments worked, but the state can prohibit that. Here we have a state that wants to prohibit gender-related medical treatment in the form of talk therapy, but we now have the First Amendment that is inhibiting the state's ability to do that. And I'm just, from a very, very broad perspective, concerned about making sure that we have equivalence with respect to these things.
I think this is why the case so far is focused on speech rather than treatment. Now, since I've already shown that this law cannot violate the First Amendment, it looks like Ms. Chiles' case should go down in flames. But there's more to this. I think the fundamental flaw in this case is its reliance on the First Amendment and freedom of speech. While the First Amendment doesn't apply because Congress did not make this law, the Constitution of Colorado sure does. No law shall be passed impairing the freedom of speech. Every person shall be free to speak, write, or publish whatever he will on any subject, being responsible for all abuse of that liberty. Again, I think the free speech argument has a fundamental flaw, one that was exposed under Skrmetti. The state is attempting to regulate treatment, not merely speech. But as I mentioned, just because the First Amendment and free speech aren't the issue, that doesn't mean that there isn't a constitutional violation in Colorado's law, specifically due process. From the 14th Amendment, we read, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law." You see, Colorado has passed a law that not only deprives Ms. Chiles of the liberty to practice her trade, but deprives her clients of a desired treatment. Now, this would be allowable if Colorado had followed due process, which is defined in the Free Legal Dictionary as an established course for judicial proceedings or other governmental activities designed to safeguard the legal rights of the individual. See, in this case, that would mean showing that the treatment banned by law was actually harmful. And remember, the state has the burden of proof, not the individual, as Mr. Campbell pointed out under Justice Jackson's questioning.
Our expert materials also recognize that they cannot prove harm. We've cataloged all the places in their expert materials on page 22 of our reply brief where they concede that. And lastly, their own expert materials recognize that many people have experienced life-changing benefits from this kind of counseling. Again, the APA's own report talks about how this helps people because they're able to align their life with their religion. They're able to find deeper relationships with God. They're able
Doesn't
to
Colorado have some evidence that conversion therapy more broadly is harmful? I mean, I think there are like 25 states or something who have similar laws. So someone has some evidence related to the harmfulness of this activity, right?
Colorado certainly cites studies, but those studies suffer from significant flaws. The main flaw in all of them is that they lump together dissimilar approaches. They treat voluntary conversations the same as shock therapy.
This topic was also brought up by Justice Sotomayor in her questioning of Mr. Mooppan.
The thing that gives me pause in not applying strict scrutiny or in applying it is that none of the studies say that talk therapy is harmful. Is that correct?
Justice Barrett gave Ms. Stevenson the opportunity to answer that question.
What is your best evidence on this record, thinking about the application of strict scrutiny, that this kind of talk therapy by licensed therapists to minors causes harm?
Sure. I would direct you, Your Honor, to JA 64 through 74. And I do want to note this particular argument about this specific study came up for the first time at 10th Circuit oral argument. And I think had we had an opportunity, we could absolutely have put in even more evidence to nail this down in the district court. But if you look there, our expert walks through all of the research that's been done since 2009. Aversive practices have not been in use since the 1980s or before, so all of these studies do not concern aversive practices at all. And then I would direct you specifically to the Green study and the Turban study. The Green study looked at 34,000 13 to 25-year-olds who had gone through conversion therapy, and after controlling for other factors, found there was a 2 times rate of attempted suicides among that group. And in the Turban study, Dr. Turban looked at 27,000 participants. This was specifically on gender identity change efforts, including people who had received those efforts at under the age of 10. He looked specifically at childhood exposure and found association with adverse mental health outcomes in adulthood, including suicide ideation and attempts.
That all sounds pretty good until we look at Mr. Mooppan's response to Justice Sotomayor.
For this type, for talk therapy by a licensed therapist to minors, they don't have any studies that say that that is either harmful or ineffective. And indeed, they often concede that they don't have that. The 2009 APA report expressly acknowledges, at pages JA 221 and 256, expressly acknowledges that they don't have evidence of that. And if you look at the Glasgow Declaration, which is after 2009, she too doesn't cite anything. If you look at the studies that she cites in her declaration, all of them are conflating either aversive and non-aversive, or licensed and non-licensed, or minors or adults. They just don't have anything.
Except according to Mr. Campbell in his rebuttal.
On the issue of studies, there was a reference to the Green and Turban studies. All of those studies relied on bias sampling, self-reporting. They conflated aversive techniques with voluntary counseling. They did not isolate licensed counselors, and they did not purport, even in their own study, to prove causation.
So is it the quantity of studies or the quality of those studies that provides proof of harm? As Justice Barrett reminded Ms. Stevenson, she has the burden of proof, not Ms. Chiles.
But you bore the burden. She didn't have to show that it was efficacious, right? You had to show that it caused harm.
Right, but in light of 100 years of studies that all point in the same direction with no efficaciousness and evidence of significant risk of harm, we think we amply carried that burden.
So not only did Ms. Stevenson completely ignore the arguments by both Mr. Campbell and Mr. Mooppan about the quality of the studies, she also ignored the harm caused by the law, as Mr. Campbell noted.
But one of the things that's so problematic about Colorado's law is that it undermines the well-being of kids that are struggling with gender dysphoria. And so Colorado accepts that up to 90% of kids who struggle with that before puberty will work their way through it and realign their identity with their sex. But this law says that if any of those children go to a licensed professional and say, I would like help realigning my identity with my sex, that licensed professional has to decline to help them.
If 90% of children who struggle with gender dysphoria work through it and realign their identity with their sex, isn't preventing them from seeking help to do so harmful? Thereby, they are denying these children the liberty to seek treatment, not because it is harmful or ineffective, but because it does not align with the political views of the state. As bad as the case brought for Ms. Chiles was, Mr. Campbell does get to the point during his rebuttal.
This law harms gender dysphoric kids because the statistics that we've cited in our verified complaint, as well as in the brief that we cited with this court, indicate that 90% of young people who are struggling with gender dysphoria before puberty work their way through it and realign their identity with their sex. But if one of those children go to a counselor and they specifically say, that is the help I want, realigning my identity with their sex, they cannot receive that help from someone like my client.
Rather than protecting children from harm, this law prevents minors from getting the treatment that 90% of them need. The evidence that conversion therapy is harmful is questionable at best and medical malpractice at worst. I wonder what would have happened if Ms. Chiles' legal team had studied the Constitution rather than constitutional law. Perhaps not only would they have brought a sounder argument, but they also would not have tripped over the Skrmetti case. So that's the Chiles case. That's the question of Colorado's law against conversion therapy. Not a well-constructed case, not even a well-argued case, although there were some interesting points in it. This dependence on freedom of speech in the First Amendment shows the fundamental flaw in the argument. It can't be First Amendment because Congress didn't make the law, and this is not about speech, it's about regulating medical treatment. But if the state's going to deny the ability to give or receive medical treatment, they have to follow due process. They're depriving someone of the liberty to exercise to live the way they want. The state has a burden of proof to show that it is dangerous, that it should not be allowed. And so far, they haven't done that to my satisfaction. The question is, have they done it to the satisfaction of the justices of the Supreme Court? We'll have to see. The decision will come out later probably early next year. And we'll see how they slice this onion. Will it make everybody cry? Will it make somebody cry? The point is, from a constitutional standpoint, from the Constitution studies idea, we see the flaws in the argument so that we can make a better argument. We see the flaws in the case so we can help people build a better case. And that is really what the Constitution studies are all about. It's reading and studying the Constitution so that we not only recognize when our rights are violated, but we're better prepared to defend and assert them. Now, if you'd like to find out more, head to the website, constitutionstudy.com. You can ask a question, you can sign up for a mailing list, head to the store, maybe purchase a book, or just donate to the cause. Nobody here takes a salary, so everything goes to keeping the Constitution Study up and running. By the way, you can support us with your cell phone. By the way, you can support the Constitution Study with your cell phone. Patriot Mobile is America's only Christian conservative wireless provider, and they support organizations like the Constitution Study that are defending your rights. Just go to patriotmobile.com/constitution, find a plan that works for you, see if you're eligible for a discount, and then when you check out, use the code Constitution to get your line activated absolutely free. That's right, you can support the Constitution Study with your cell phone by going to patriotmobile.com/constitution, finding a plan, signing up, and remember, use the code Constitution to get your line activated absolutely free. Now, I hope you enjoyed this episode. I hope you'll come back and join us, and hey, maybe bring a few friends the next time we meet for the Constitution Study.
neighbors and have a few good friends.